Am I audible now? Perfect. So, do you remember previous discussions? Let's revise once. एक बार revise कर लेते हैं. It will be easier for us to carry on forward. So far, what else have we discussed? We discussed about reservation. What is the criteria for reservation? Just quickly tell me. What is the criteria? Hello Amrut. Amrut, did you happen to follow the last lecture? Social and educational backwardness. Perfect. Social and educational backwardness. Now this is provided under which article? Provided under Article 15, or particularly Article 15 Clause 4, and criteria provided under Article 16 Clause 4 is any backwardness. Any backward class of citizens. Please remember that in OBC, generally the word used is OBC, it is other backward class, not caste, and it is also referred as SEBC. So it is possible that in your exam, you know, the term mentioned is not OBC but rather SEBC, because this is the correct word according to Article 15 Clause 4 and also 15 Clause 6. This is the correct word. Okay? Correct. What else? How much is the maximum limit of reservation allowed? Kitna allowed a reservation? Yeah, 15.6 for EWS. Correct. How much is the maximum reservation allowed so far? Whatever we have studied? 50%. Perfect. Maximum 50%. But can this 50% cap be breached? Can there be more reservation beyond 50%? Let's say exam में एक statement आता है that according to the Constitution of India, it defines and limits the cap of reservation at 60% or 50% or 55%. This statement would be incorrect because Constitution of India doesn't say anything about percentage or quantum. This is based on an understanding of the judgments, of course, right? So this is another thing. एक और issue जो उठा regarding reservation था, वो था sub categorization. Now sub categorization simply means that, let's say this is the community of SEBC. Then among SEBC, can we say that this particular people are more backward? These particular people are more backward, and since they are more backward, hence they need reservation in priority or in preference as compared to the other people who are not that much backward. So whether was this subcategorization allowed with respect to OBC? Is reservation mentioned in the Constitution? You are asking about this word reservation. I don't think so. Reservation बोल के. We'll see. But what about subcategorization? Is it allowed? Not allowed? I'm revising so that Amrutesh and Fatma can also benefit from this discussion. So quickly, tell me, Krishna, you were there. Is subcategorization allowed? Is subcategorization allowed under reservation? Fatma, what about you? Yes, creamy layer and non-creamy layer. So within OBC it is allowed with respect to creamy layer and non-creamy layer. ये कहाँ बोला गया? क्या ये कॉन्स्टिट्यूशन में लिखा हुआ है? Is it mentioned in the constitution? No. This was highlighted for the first time in Indira Sawhney judgment. Indira Sawhney judgment में पहली बार ये बोला गया कि yes, there could be classification based on who are creamy layer or who are more advanced section and who are less advanced section within a given community, and those who are more advanced section can be removed from the benefits of reservation. ठीक है? Did Indira Sawhney also approved sub-categorization for scheduled caste and scheduled tribe, particularly for scheduled caste? Was sub-categorization allowed for scheduled caste? No, not under Indira Sawhney. But what is the present situation regarding sub-categorization of scheduled caste? It is allowed according to the recent Supreme Court judgment of Davinder Singh. Okay? The courts have finally said that yes, you can do it. When we'll talk about scheduled caste, scheduled tribes, Article 341, 342, इसको और डिटेल में समझेंगे, because then we will also understanding how these communities are included in the list. But as of now, just remember that Indira Sawhney did not say so, but the present situation is that according to Davinder Singh versus State of Punjab, Davinder Singh versus State of Punjab, sub-categorization within scheduled caste is allowed. That is, even within scheduled caste, government can look into who are more advanced, who are less advanced, or who can be given priority in terms of reservation. Another important thing which we discussed in the previous lecture was that can reservation be given for in cases of promotion to members of scheduled caste and scheduled tribe? Yes, no? Can reservation be given to members of scheduled caste and scheduled tribe on promotion? Yes. 16(4)(a). It's okay. At least you remember that much. This is allowed in 16(4)(a). This was added by Constitution 77th Amendment. So which judgment approved this? Which judgment said कि हाँ, this is perfect, there is no problem as such in reservation? M. Nagaraj versus Nagaraj, correct. M. Nagaraj versus Union of India. एक और aspect है इस discussion में which we had in the previous discussion, that too very elaborately. The discussion was relating the relationship between reservation on one hand. So on one hand, yes, reservation is important, we have seen that, but on the other hand, efficiency should not be compromised. Efficiency in administrative services should not be compromised. ठीक है? And this is highlighted under Article 335, which says that yes, states or the government can provide reservation, or particularly reservation in promotion to scheduled caste and scheduled tribe, or any other reservation, but it should be ensured that efficiency in efficiency of administration is not hampered. So this balance, this is the duty of the government to ensure this balance, कि इतना भी reservation मत दे दो कि hamper हो जाए, efficiency hamper हो जाए. And lastly, is reservation an exception to equality? Is reservation an exception to equality? No. It's now considered to be part of equality code. But there is another side to the story. So far we studied that yes, reservation earlier was considered to be an exception to equality, but after N.M. Thomas judgment, it was declared that no, it's a part of extension of equality code. But I'm asking you a different question. Fundamental rights it's such rights whereby you can ask certain rights. Okay? Fundamental rights are those rights. Let's say the government infringes your rights, then in that way you can go to the court and saying ki, see, this is my fundamental right which is infringed. Can the citizens go to the courts and saying it is my fundamental right of reservation and hence the government has to provide policies or make a reservation in education or employment? You understand what I'm asking? No. Reservation per se अगर मिलता है तो अच्छी बात है, but reservation in itself is not a fundamental right. It's merely an enabling provision. That is, Article 15.4, 15.5, 15.6, 16.4 enables a state to provide certain affirmative action through reservation. But citizens cannot claim it as a fundamental right. Yes, it has been considered as a part of equality, but not something which a citizen can claim. Okay, so fundamental right overall in general, fundamental right has a negative connotation, It means it is not something which is provided to you. It's not like that. But it is something which cannot be taken from you. It is not something which is provided to you outrightly, but it is something which cannot be taken from you. So let's say under part 3, these are your fundamental rights, the different 6 in general, the 6 type of fundamental rights plus Article 12 and 13 and plus Article 31A, 31B and 31C. So these are your fundamental rights. The meaning that fundamental rights have a negative connotation, it means that these fundamental rights cannot be taken away from you. Cannot be taken away. By government in an arbitrary manner. So let's say if your fundamental right to life and liberty is being encroached upon, it also means that government cannot, in simple terms, government cannot encroach upon your fundamental rights. So in that sense, these fundamental rights acts in a negative way. And the state cannot encroach upon your fundamental rights. Let's say state takes certain action whereby one of your fundamental rights are being encroached. It cannot be done. You can move to the courts. For what purpose? For a solution or a remedy. This is general understanding, and that's why if you look at the formation of the statement of fundamental rights, अगर आप देखोगे, let's focus on exactly how the statements are framed, then it generally starts on a negative concept. The state shall not do this, the state shall not do that, the state shall not take away, the state shall not discriminate. It generally starts from a negative connotation, meaning that fundamental rights cannot be taken away by the state. And if they take so, then you have a right provided as a part of fundamental right itself to move to the court under Article 32. एक एस्पेक्ट ये है. दूसरा एस्पेक्ट इस डिस्कशन का ये है कि कैन स्टेट never take away your fundamental rights, or there are certain possibilities, there are certain circumstances in which state can take away your fundamental rights, or at least some of them. What do you think? During emergency, so there are certain circumstances in which state can take away your fundamental rights, not even during emergency, even during normal times. फातिमा, normal times में भी state आपका fundamental rights थोड़ा सा infringe कर सकता है, उसके conditionalities अलग है. Always remember one thing while studying constitution, while studying polity, nothing is absolute. It's particularly not the fundamental rights. So just write this statement that no fundamental rights provided under part 3 of the Constitution of India are absolute. मतलब कि कोई fundamental rights absolute नहीं है. Let's say there is a fundamental right to equality, state can make certain exceptions, or state can provide certain affirmative actions. In that sense, obviously reservation is an exception, although considered to be a part of equality code, but है तो exception ही ना, या तो privilege कह लो, या तो affirmative action कह लो. So when we'll start reading or understanding right to freedom, which we will do very soon, then this is something which you must understand, that no fundamental right is absolute. State can infringe some part of your fundamental rights, provided obviously it meets certain condition or qualification, and one condition or qualification is Article 14 itself. So this is something which we must understand today. And also the correlation between, have you heard about this concept of the golden rights, the golden triangular fundamental rights? Article 14, Article 19 and Article 21. It is referred as these three fundamental rights are referred as the golden triangle. Write it here. One of my professors back at college in law school used to teach us that give me 4 articles. He used to, very jokingly or famously, he was very famous about this. He used to, in a very jokingly manner used to say, we did not understand then, of course, we were just kids, that give me Article 14 and Article 256 and I will sweep the entire sky beneath my feet. This was his quoted statement in the college, and we used to laugh at what he is saying, because we never understood what he was exactly saying. We'll also understand this from this perspective. So these 4 articles have immense power, not only for citizens but also for states. ठीक है? Fundamental rights के overall 2 aspects हैं. Please remember this. Fundamental rights के 2 aspects हैं. There are 2 important cardinal principles with respect to fundamental rights. First, no fundamental right is absolute. No fundamental right is absolute. Now, it has 2 meanings. First is that state can restrict some fundamental rights based on law made by either parliament or state legislature. or state legislature. No fundamental right is absolute, and one part of it is state can restrict some fundamental rights based on law made by parliament or state legislatures. Such law to restrict fundamental rights, such law to restrict fundamental rights must not be arbitrary. Must not be arbitrary, and second, must be reasonable. And third, the restrictions imposed must have a rational nexus with the object which it seeks to achieve. Simple meaning, let's say if your right to movement is restricted, we have studied inner line permit, right? If your movement is restricted, उसका एक valid reason होना चाहिए. क्यों movement restrict हुआ है? क्योंकि उस area में अभी ना law and order problem है. आप जाओगे तो you will be hurt and hence your movement is restricted. Certain trade are restricted, like and the government issues licenses. For example, trade with respect to certain explosives, because those are not normal thing, and hence government can regulate certain aspects of your trade, and right to trade is part of Article 19. So certain restrictions can be made. State can restrict some fundamental rights based on ordinary law, either made by parliament or state legislature. Such law to restrict fundamental rights must not be arbitrary. मनमाना नहीं होना चाहिए. ऐसे मन किया तो बना दिए आपका मैं fundamental rights infringe कर लिया. Because if a restriction is arbitrary, then it can be challenged in a court of law. This can be challenged in courts. So this is the first part. No fundamental right is absolute. Can you guess the second part? Zero traffic? What is zero traffic? I am not aware of. Some kind of restriction? If it is of some kind of restriction, then yes, it is definitely allowed. And second, regarding fundamental rights, is that it grants protection to citizens with those fundamental rights mentioned in part 3. Obviously, and that's why this whole fundamental principle. I will come to that. Third, and a very important point with respect to two important judgments, A.K. Gopalan and Menaka Gandhi, that fundamental rights are not isolated chambers. Fundamental rights are not isolated chambers. I'll explain you the meaning. Suppose government came up with a law to send people in jail government came up with a law, let's say a preventive detention law, to send people in jail on certain arbitrary grounds, या जो भी उनका मन किया. Now the question is that can this law be, and this law which is sending people to jail without any procedure, let's say it is violating article 21. मानते हैं ऐसा कि ये आर्टिकल 21 को वायलेट कर रहा है. कैसा लॉ? एक प्रिवेंटिव डिटेंशन लॉ, एक प्रिवेंटिव डिटेंशन लॉ where there is no process provided, where there is no process provided once a person is lodged in jail, where no process is provided once a person is lodged in jail. So the question is that ki, let's say if a fundamental right, let's say if article 21 is infringed, can we only see that whatever the law was made by the government, whether it infringes only article 21, or this law can also be subject to, let's say, a law made under article 14 or with respect to article 14 or 19. मतलब कहने का कि if a law is being challenged on a particular ground, let's say it is being challenged to be violated under article 21, can it be also seen as in violation of article 14 or 19, or let's say any other article? Another example of Bandhwa Mukti Morcha, where people were working in extreme harsh conditions, and because of the extreme harsh conditions they were working in asbestos factory, and because of extreme harsh conditions they were also suffering from physical diseases, and the government was not looking after them. On top of that, the government was also not paying them wages. So technically this was a violation of article 23, but can we say that since it involves their day-to-day life and livelihood, it also affects, since they are not being paid wages, article 19, and of course overall article 21. So basically the question is that can a violation of fundamental right can also be looked into from the perspective of violation of other fundamental rights? Okay, are you following this? This was the contention earlier, and A.K. Gopalan said that all these judgments, all these articles are watertight compartments. But Maneka Gandhi reversed this understanding. So these are some of the basic aspects with respect to freedom. Because freedom is essence of liberty, or liberty is essence of freedom. Because without freedom, you're not really free, and freedom does not only mean physical freedom, it also means cognitive freedom, freedom to think, freedom to say anything, freedom to go anywhere, freedom to choose any profession, freedom to criticize anyone. But does freedom to criticize also mean freedom to defame someone? So there are limitations. सब कुछ नहीं allowed है, हर चीज बैलेंस्ड में अलाउड है. रिमेंबर गांधी जीज बैलेंस्ड अप्रोच. फंडामेंटल राइट इज ऑल अबाउट गांधी जीज व्यू और गांधी जीज विजन ऑफ अ बैलेंस्ड अप्रोच. नथिंग इज इन एक्सट्रीम. ऐसा नहीं बोला गया कि सिटीजन को बोल दिया गया कि आपके पास एकदम खुला राज है, जो करना है करो अंडर द गाइज ऑफ फंडामेंटल राइट्स. नो, समवन हैज फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन. यस. कैन दे एड्रेस अ पॉलिटिकल रैली? यस. बट in the name of addressing a political rally, can they create chaos in the society? No. Can they say something to the masses, say something to the public which leads them to do some kind of violence? No. So fundamental rights are subject to reasonable restrictions. This is the basic understanding of any fundamental right. कोई भी फंडामेंटल राइट ऐसा नहीं है जो कि एब्सोल्यूट है. देयर इज नो फंडामेंटल राइट विच इज एब्सोल्यूट. राइट टू प्रिवेसी इज नॉट एब्सोल्यूट. राइट टू फ्रीडम ऑफ स्पीच इज नॉट एब्सोल्यूट. आई हैव अ फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन, सो डू यू, बट डज इट मीन आई स्टार्ट सेइंग एनीथिंग इन फ्रंट ऑफ यू? नो. देयर इज अ decorum of this class which we all maintain. There is a decorum with respect to which we discuss, and there is a decorum with respect to which you also interact. So everything has to be done in certain limitations. On this note, let's understand other parts of fundamental rights. Any doubts so far in this part of the discussion? Okay. Okay, who asked this? Amrutesh Krishna. When politician convoy goes, police just stop movement from using the same roads for 30 minutes. Special privilege? Can we say that? Or reasonable restriction? What do you think? Special privilege, but for what purpose? Privilege गलत नहीं है, reason होना चाहिए. But generally, stopping of traffic is not allowed unless someone is of a very high dignity. Okay. एक और चीज है, constitution in theory and constitution in practice. Do you think there is a gap? Constitution in theory and constitution in practice. Do you think there is a gap? This is a very big topic. You don't think it's a very simple topic. It's a very big topic of PhD research. A lot of PhD research has happened on various parts of the constitution regarding the gap between theory and practice. Custodial death is, yes, another issue. In fact, what you are referring to has happened. I'm not sure about the recent ones, but there was one custodial death, particularly which happened just after the one death which happened in America of a black person. Custodial death comes under which right? We'll discuss that. Article 22 and 21. Let's take step by step. Okay. Okay, to all of you जिनके साथ मैंने अभी डिस्कशन किया रिजर्वेशन का, just go through this question asked by UPSC in the prelims of I think 2024. Fatma, Amrutesh, who else is here? Bhagishri. I'll read the statements because see, directly questions are being asked. The statement is, consider the following statement. Statement 1, the Supreme Court of India has held in some judgments that the reservation policies made under Article 16(4) of the Constitution of India would be limited by Article 335 for maintenance of efficiency of administration. Yes, Amrutesh, what do you think about this one? अभी just discuss किया था मैंने. Correct, incorrect? Fatma, what about you? Bhagishri? अभी तो डिस्कस किया. It should be balanced. This is correct. Second, Article 335 of the Constitution of India defines the term efficiency of administration. No, it does not define. So, statement 1 is correct and statement 2 is incorrect. Correct. So we need to have a crux of understanding of these judgments. So let's go to, after this, let's go to Ashok Kumar. In this Constitution 93rd Amendment was declared perfect. Let's discuss this along with right to education of right to Article 29 and 30. Now see this case. This is an interesting case where this concept was highlighted. Substantive equality. Now substantive equality in simple term means it goes beyond formal equality. it goes beyond formal equality. Meaning, it does not consider equality as highlighted under Article 15 and 16, but even goes beyond that and addresses various aspects of equality in the society. So it considers society and various discrimination which is taking place in the society. So one example of this was that there was a candidate who was physically handicapped, and he was not allowed a scribe in the UPSC examination. So he filed a case, and the court said ki see, it doesn't matter what the benchmark disability is. If a person is disabled, means he is different from the others because of his physical inability, you have to provide him such assistance. Recently, a permanent commission for women was also authorized in the Indian Army based on this understanding of substantive equality. So you never know, a question in your mains could be asked regarding the importance of substantive equality of late. Highlight the importance of substantive equality based on Supreme Court judgments, because of late, even in your main examination, Supreme Court judgments are being asked. Now, Article 21 पढ़ेंगे तो we will see different types of questions asked in your main examination, particularly from the perspective of these different judgments. And the topic which we will discuss now has been asked mostly, not always, mostly as a part of your main examination. Also asked in a prelims, but mains में focus ज़्यादा है because the topic which we are about to study, right to freedom, exploitation, and educational and right to cultural and educational rights, along with right to freedom of religion, all these are topics worthy of your mains. So you need a conceptual understanding on all of these. So एक issue आया ये, have you heard about this AIQS, All India Quota System, whereby quota is reserved at different levels, at the level of graduation and also at the level of post graduation? My question to you is that, do you think that when reservation is provided at a graduation level, it more or less serves the purpose, right? And hence there is no need for a reservation at the master's level. तो नहीं होना चाहिए मास्टर्स लेवल पे, क्योंकि आप एक बार रिजर्वेशन तो दे दिए, आपने उनको एबल कर दिया to become graduate. Then do you think there is actually a need for reservation at the post graduation level, particularly in important examination like engineering or medical? What do you think? Amritesh, what's your view on this? Less percentage in can be, okay, there must be. Why, Amritesh? Why do you think? It's possible this year a question could be asked, this main upcoming exam, upcoming नहीं, ये अभी September August में जो होने वाला है 22nd August को. Let's understand the reasonings provided here. So it says Supreme Court, while upholding the validity of reservation in All India Quota Scheme, not only recognized the idea of substantive equality, but also held that binary of merit versus reservation is superfluous. Supreme Court in number of other judgments has held that Article 16(1) can exist parallelly along with 16(4) and 16(4)(a) without violating the principles of equality enshrined under Article 14, because reservation is considered as an extension of equality code. Now, the argument of this case was that by the government of India that, you see, reservation is provided at the graduation level and hence there is no need for reservation, and anyways reservation eats up the merit. seats reserved for merit. Court came up with a very different understanding of this topic. Court ने क्या बोला? Court said that binary of this merit versus reservation understanding is superfluous. So it says that while ruling in favor of extending reservation to OBCs in all India quota of seats in admission to undergraduate and postgraduate medical and dental courses, court has concluded that binary has become superfluous, and one should not look at reservation merely from this single prism, that if there is a reservation it will eat up the merit class. ये वही वाली अंडरस्टैंडिंग है जो टी देवदासन और एम आर बालाजी में था, where it said that reservation is an exception to equality. So reservation is now no more an exception to equality, rather a part of an affirmative action to be taken by the state, and hence it says substantive equality not an exception. Same understanding, it's not an exception. Courts have now come to the conclusion, or to recognize the idea of substantive equality, which sees affirmative action not as an exception to the equality rule but as a face of equality norm. Almost similar lines, hardly any difference in terms of views of the court. Formal equality is inadequate. This is a very important statement given by the Supreme Court. Court says that formal equality, or principle that everyone competes on an equal footing, is inadequate to address social inequalities and the inherent disadvantage of less advanced sections, necessitating provisions that help them compete with the advanced classes. So court is saying, see, there are certain candidates who already belong to an advanced section of the community, and there are students who belong to a disadvantaged class, a disadvantaged section of the community. तो कोर्ट का ये कहना है कि आप उनसे उनका हिस्ट्री, उनका बैकग्राउंड आप नहीं छीन सकते. They have been at a disadvantageous position, and that disadvantageous position has been crept in their life ever since. So just saying that they have been given reservation at the graduation level and hence they do not need it any further, it is discounting the fact, or it is not considering the fact of their historical injustice done to them. And hence it says reservation ensures distributive justice. This is very important term. Court held that reservation is not at odds with merit but furthers merit through distributive consequences, and merit should be socially contextualized and reconceptualized as an instrument that advances social goods like equality. So it is saying कि see, ultimately when you talk about merit, it must be seen from a social background, and in our society there is extreme disparity, there is extreme inequality, and to address inequality we need this step. इसको थोड़ा सा economic aspect से समझते हैं. Let's understand from an economic perspective. Now in economy we generally study about increasing inequality in income, right? And how do we determine increasing inequality in incomes? By categorizing a section of population, one who can be said to be the haves and the one who can be said to be the have-nots. And in India, technically, if we count all the billionaires, सिर्फ billionaires को count करते हैं, and if we count the rest of the society, let's say including millionaires, then let's say चलो millionaire को भी यहाँ पे add करते हैं. So if we add millionaires and billionaires, how much percentage of national income do they hold in their hand? It's a staggering amount. And the rest of the society, which is close to, I would say, 90%, and this is the society which is mainly comprising of 10% of population. So population wise this is 10%, but economic strength wise this is close to 90%, and the relation is almost reverse. I am giving a very crude figure, it's not an exact figure, but I am trying to tell you how imbalanced our society is. This is the population and this is your income. In fact, it is even lesser. I exactly don't remember the amount. Same concept, if we highlight this not from the perspective of economy but from the perspective of society, इसको अगर हम बस सोसाइटी के पर्सपेक्टिव से लगा दें, यहाँ पे भी यही चीज एप्लीकेबल है. Those who are the haves of the society, I think red is not visible. Those who are the haves of the society, increasing social inequality. So the same idea is here, and hence reservation as a ground of affirmative action addresses not only economic justice but also social justice. Okay, that is the idea. And lastly, the court says reservation needed even for postgraduate courses, because the court has also rejected the argument that there was no need for reservation in postgraduate medical education. According to the court, impact of backwardness does not simply disappear because a candidate has a graduate qualification and does not create parity between advanced classes and backward classes. Same understanding, same idea of the basically based on the notion of equality and inequality based on social parameters. Okay? And hence substantive equality further addresses this issue of social inequality. Clear? Let's come to a Constitution 106th Amendment. Sorry, 103rd Amendment with respect to EWS. Are you clear with this concept of reservation for economically backward class of citizens? Okay. So you can go through this, but just remember one thing, that this reservation is above 50%. In fact, in total, we have 49.5% reservation plus 10% reservation for EWS. And with respect to Article 15, it says that Constitution 103rd Amendment adds a new provision, Article 15(6), whereby state can make any special provision for the advancement of any economically weaker sections of the society. Now, who are economically weaker section is not defined in the Constitution of India. It is provided by the Government of India. And it has placed a criteria of, I think, an annual household income of 8 lakhs per annum, something like that. And says state can make any special provision for the advancement of any economically weaker sections of the citizens relate to their admission to education institution, including private education institutions, whether aided or unaided. So this EWS reservation is also to be provided by private education institutions, whether aided or unaided, but not to be provided by minority education institution. However, such reservation will not apply to minority education institutions, and reservation to such education institutions would be in addition to the existing reservation and subject to a maximum of 10%. Okay? So just remember this part, that private education institutions, whether aided or unaided, उनको भी EWS रिजर्वेशन देना होगा, बट माइनॉरिटी एजुकेशन इंस्टीट्यूशंस को ये एग्जेम्पशन है. Under Article 16 Clause 6 regarding reservation to public employment, it says it adds 16(6) where the state may make any provision for the reservation of appointments or posts in favor of any economically weaker section of citizens in addition to the existing reservation and subject to a maximum of 10%. Same point. And the reservation of 10%, up to 10% for economically weaker sections in education institutions and public employment will be in addition to the existing reservation. And the central government will notify economically weaker sections of citizens on the basis of family income and other indicators of economic disadvantage. This constitutional amendment was also challenged in the court. What do you think? Is this against 50% rule? Is this reservation against 50% rule as set out in Indra Sawhney judgment? write the name of this case. Important है. जनहित अभियान versus Union of India. I am asking your opinion. Judgment तो देखते हैं बाद में, but think. You have understood everything about reservation. ऐसा कुछ भी नहीं बचा जो आप reservation के बारे में अब नहीं जानते हो. So based on your understanding, whatever you have understood, give me 3 points in favor of this judgment and 3 points against this judgment. चलो बताओ. Yes, Amrutesh. 3 points in favor of this. Sorry, 3 points in favor of the constitutional amendment or EWS reservation. 3 points in favor of EWS reservation and 3 points against EWS reservation. I'll write it here. Before moving further, I want to make you think that Constitution 103rd Amendment provides reservation for EWS. कुछ नहीं करना है आपको, इसके 3 पॉजिटिव पॉइंट बताओ और 3 नेगेटिव पॉइंट बताओ, एंड दिस विल बी योर आंसर फॉर अ क्वेश्चन ऑन क्रिटिकल एनालिसिस ऑफ दिस जजमेंट. दिस विल बी योर आंसर टू अ क्वेश्चन रिगार्डिंग क्रिटिकल एनालिसिस ऑफ जनहित अभियान. वर्सेस यूनियन ऑफ इंडिया. चलिए बताइए. दिस वुड अंडरमाइन रिजर्वेशन ऑफ द एक्सप्लॉइटेड क्लासेस. तो ये नेगेटिव हो गया ना अमृतेश. ओके. अंडरमाइन रिजर्वेशन ऑफ एक्सप्लॉइटेड क्लासेस, क्या मतलब हुआ इसका? Who are the exploited classes, by the way? Directly, first point, it contradicts 50% rule as highlighted in Indra Sawhney. ठीक है. अच्छा, नॉन क्रीमी लेयर्ड ओबीसी, हाउ इट विल अंडरमाइन? हाँ, ये पॉइंट रेज किया गया था दैट विदिन 10% रिजर्वेशन इज नॉट प्रोवाइडेड. Within 10% reservation is not provided to members of SEBC, SC and ST. This was definitely one of the point raised during the court arguments. Those of the upper classes could also get reservation under this. ठीक है, तो इसमें गलत क्या है? गलत क्या है इसमें? As long as there is a justifiable criteria, please understand this. कोई भी रिजर्वेशन किसी के लिए भी हो सकता है, पहली बात. दूसरी बात, if there is a justifiable criteria, then I don't think, or at least we can say that if there is a justifiable criteria to provide reservation, at least we can say that it is not arbitrary. And what is the justifiable criteria here? That you are trying to provide reservation on economic criteria कि भाई who are economically weaker based on certain income level of the household income, ऐसा भी नहीं कोई एक बंदे का income, overall household income, then they can be given reservation. So criteria is justified. It's just that in the Indra Sawhney judgment itself, the court said that reservation cannot be provided on economic criteria alone. Reservation cannot be provided on economic criteria alone. सिर्फ इकोनॉमिक क्राइटेरिया पे रिजर्वेशन नहीं दे सकते, ऐसा सुप्रीम कोर्ट ने कहा था इन अगेन इंदिरा सोनी. सो फॉर टू अंडरस्टैंड Constitution 103rd Amendment and its case on AWS, you must have a very clear understanding of Indira Sawhney judgment. But the state must ensure that they are truly economically weaker. ठीक है, तो state is ensuring by providing those rules. The Ministry of Personnel has come up with very elaborate rules. I'm sure if you have applied for UPSC, you will be knowing whoever fits into that criteria. So the rules are there. पॉजिटिव अभी तक किसी ने नहीं बोला है. It is an affirmative action and helps to fulfill the mandate under Article 46 to address concerns of economic weaker section of the society. What else? Any other positive? Reservation is not a poverty elimination program. Okay. Excuse me. Court said in its positive second point that it does not violate Article 14. It does not violate Article 14 because there is a reasonable criteria. There is a reasonable criteria based on economic backwardness. Based on economic backwardness. And regarding reservation for not provided to other members, it says that उनके लिए अलग percentage of reservation is already fixed. And also the court said that it does not violate basic structure. It does not violate basic structure. It does not violate basic structure. So I'm just giving you a sort of an understanding with respect. This is a very important judgment actually. You should know about this judgment. Because see, this judgment you will not find it in any book. Book में नहीं मिलेगा आपको ये. So I'm trying to also incorporate whatever important landmark developments has taken place with respect to certain important part of your syllabus. Okay, if you want to take a screenshot, please do. So this is your answer to this. In fact, ये वाला point valid नहीं है. इससे बेटर आप ये लिख सकते हो कि it eats into the seats which remains for general class. which remain for general category. Okay. Because this reservation is over and above 50%. Okay, let's move further. Balances social justice with economic justice, correct? वो article 46 में you can highlight that one. But again, if you see, because of EWS, provisions were added where article 15 clause 6 and 16 clause 6. And here the government is saying that we are introducing this to fulfill article 46, जो कि पहले भी government ने बोला था when it introduced reservation earlier during Mandal Commission time. Does this mean the previous judgment of Indra Sawhney gets overruled? No, outrightly the courts have not overruled the 50% quota. Let's go through what the court have said. Court have not overruled Indra Sawhney. Court have gone in a very different manner. So, two legal issues were raised in this particular topic. See, first was economic criteria, whether amendment breaches the basic structure by permitting the state to make special provisions including reservation based on economic criteria, because this was prohibited by Indra Sawhney. And hence this question also raised. This question was, a legal issue was highlighted, that does it violate the basic structure? Second, admission to private unaided institutions, whether it violates the basic structure by allowing the state to make special provisions in relation to admission to private unaided institutions. And also exclusion of OBC and SC ST, whether basic structure is trampled or violated when you are not including SC, ST and OBC within the 10% EWS quota. तो फिर तो उनके लिए क्या ही सीट बचता है ना. अगर आप 10% में, लेट्स से 10 सीट में भी आप फिर शेड्यूल्ड कास्ट, शेड्यूल्ड ट्राइब एंड SEBC के लिए सीट रखोगे तो इनके लिए तो फिर कुछ भी नहीं बचेगा. So, but these were the three legal issues raised in this particular topic, and the government argued that basically the idea was to implement Article 46 as part of DPSP. Government has a duty to protect the interest of economically weaker section of the society. It must be shown that Constitution has been altered to sustain a challenge of violation of basic structure. And on unaided education institutions, Constitution allows the Parliament to place reasonable restrictions on the right to carry on trade. And Ashok Kumar Thakur case was also highlighted, जहाँ पे ये बोला गया था कि Constitution 93rd Amendment is perfect. So relied on Supreme Court judgment, where Supreme Court upheld the 27% quota for OBCs, and court accepted that definition of OBCs was not made on the sole criteria of caste, but a mix of caste and economic factor. And hence the judgment, the court said that reservation is an instrument of affirmative action by state to ensure an all-inclusive march towards goal of egalitarian society. Reservation solely on economic criteria does not violate basic structure. Now this was a subtle change from Indra Sawhney, definitely, but it did not outrightly overrule Indra Sawhney. कहीं ऐसा लिखा नहीं है जजमेंट में. Reservation for EWS does not violate the equality code because it's an extension of it. Reservation for EWS over and above 50% cap does not violate basic structure as well. Treating EWS as separate class is reasonable because the criteria is very much defined. The criteria is very much defined. And hence we cannot say that the ground to provide EWS reservation is arbitrary. ये हम नहीं कह सकते. And does not affect special rights of SC, ST, OBC despite their exclusion. Why? Because they are already included in a set of reservation. For SC, the reservation is 15%. For scheduled tribe, the reservation is 7.5%. And for other backward class, the reservation is 27%. तो कोर्ट का कहना है कि भाई इनको तो रिजर्वेशन मिल ही रहा है, तो ये कैसे एक्सक्लूड हो गए? यहाँ तो दूसरे ग्रुप ऑफ पीपल की बात हो रही है. वी आर टॉकिंग अबाउट अ डिफरेंट सेट ऑफ पीपल, एंड हेंस दिस रिजर्वेशन ऑफ एक्स्ट्रा 10% इज नॉट इवन ईटिंग इनटू देयर रिजर्वेशन. यू आर नॉट प्रोवाइडिंग रिजर्वेशन विद इन रिजर्वेशन. यू अंडरस्टैंड? लेट्स से इफ आई टेल यू रिजर्वेशन विद इन रिजर्वेशन कि ठीक है, अमंग 27% let's fix 5% seats for women. So this would be reservation within reservation, also referred as horizontal reservation. That उसके अंदर ही आप reservation दे रहे हो. That within the quota of 27% you have to provide 5% reservation. Okay? Clear? Any doubt on EWS? I think we have completed everything on reservation now. कुछ भी नहीं बचता है. Krishna, Amritesh? Okay, let's move forward. Just remember one more thing since we are discussing reservation. So reservation to other backward class provided in panchayats and municipalities इस वाले रिजर्वेशन में there is no differentiation between a creamy or a non-creamy layer because the criteria is political backwardness. The criteria is political backwardness, and it is very different from criteria of reservation or criteria of backwardness under Article 15(4). क्या है Article 15(4) का criteria? Socially and educational backwardness. So just remember this, that when reservation is provided to other backward class in elections to panchayats and municipalities under Article 243 D6 and under Article 243 T6, तो यहाँ पे हम OBC में फिर bifurcation नहीं करते हैं. We do not bifurcate OBCs not bifurcated into creamy or non-creamy layer. Okay? And to provide reservation to local bodies, panchayats and municipalities under this provision, state government must fulfill 3 criteria. This is referred as triple test. Must fulfill 3 criteria. पहला क्या है? पहला है a dedicated commission must be constituted. This commission to find out empirical data that in a district or in a municipality or in a panchayat or in a given area, how many of the people are or how many people belong to other backward class. Then ascertain, based on this empirical data, ascertain the proportion of reservation to be provided. Ascertain the proportion of reservation to be provided. And third, आपको जितना मर्जी रिजर्वेशन देना है दो, कोई प्रॉब्लम नहीं है, बट overall cap of 50% should not be violated. Overall cap of 50% should not be violated. Okay, clear? This is regarding your reservation under panchayats and municipalities. Now these provisions mentions that reservation should be given to the other backward class, but what should be the manner, in what ways reservation should be given, how much reservation to be given, it is not provided in the constitution. And accordingly the Supreme Court in one of the judgment, Arun Gavli judgment, has highlighted that state government must fulfill the triple test, and based on this triple test provide these reservation. What are these triple tests? The state government must constitute a dedicated commission. A backward commission must be constituted to find out how many people belong to the OBC criteria in a given district or in a given state. Then based on the percentage of based on the number of people belonging to other backward class, decide the percentage of reservation which is to be given based on the proportion. Agar members of OBC are very less, then give them slightly higher reservation. If member of OBCs is much larger, then give a very lesser number of lesser percentage of reservation. And third, whatever percentage you give based on the empirical data, the overall cap of 50% should not be breached, should not be violated. Fatma, first point is clear. Dedicated commission must be constituted. और इसको ऐसे लिख लो, डेडिकेटेड कमीशन के बजाय बैकवर्ड कमीशन must be constituted. Okay, so constitution under article 243 D6 and 243 T6, ये दोनों provision में it does not provide, constitution does not provide the percentage or manner of providing reservation to other backward class. And in this, the criteria to determine backwardness is not at all similar to that used in article 15.4 or 16.4. OBC, not SC/ST, other backward class. I think this was one topic you guys needed a lot of clarity, what I understand. बाकी में आपको ठीक ठाक क्लैरिटी है. Am I right in my assessment? Krishna, Amrutesh, Fatma? Okay. Have you written this, all of it? Sure. Let's move further. Let's move to Article 17. Article 17 is very important, and Article 17 is correlated to Article 23 also. I'm removing this, okay? some important point to be noted regarding Article 17. वो क्या है? वो ये है abolition of untouchability. See how it starts. It simply says abolition of untouchability. कैसे होगा? How it will happen? Untouchability is abolished and its practice in any form is forbidden. Clearly, it is abolished and its practice in any form is forbidden. And enforcement of any disability arising out of untouchability. So there are two connecting terms, disability connected with untouchability, shall be an offense punishable in accordance with law. So if because of untouchability, if it leads to any kind of disability, please understand this is a very wide term. Any kind of disability. We'll see what kind of disability there can be. Whatever disability it results into shall be an offense punishable in accordance with law. Do you know the meaning of this term? Offense. What is the meaning of what does offense means? Anyone? What does offense means? For which there is a punishment. For which there is a punishment in the form of imprisonment or fine. For which there is a punishment for imprisonment or fine under any law. तो अब law क्या है? ये है. So under Article 17, this law has been made, the Protection of Civil Rights Act 1955, and it explains and defines different types of disabilities. Yeah, that which is illegal, but all illegal acts are not an offense, Amrutesh. The technicality of it. It's not necessary that all illegal acts are offense. Okay, but let's not go into it. Okay, it says an act to prescribe punishment for preaching and practice of untouchability. Now, two things highlighted here. One is that either you preach untouchability or you practice untouchability, both are punishable. So, punishment दोनों के लिए, preaching के लिए भी है, practice के लिए भी है, for enforcement of any disability arising therefrom from matters connected therewith. Now, this is important to understand. The connection between disability and untouchability. And there is a third aspect, although not directly mentioned either under the constitution or under this law, but that third element is that of caste. If there is a disability because of someone's caste, let's say someone is a scheduled caste, which is also referred as Dalits, and because someone being of scheduled caste, they are being disabled or not able to perform certain function. What sort of function or what sort of disability here we are talking about? Economic disability. If someone belongs to a Dalit or a scheduled caste, is not allowed to open a shop, is not allowed to open a restaurant or anything, he is not allowed to work, he is not taken as a worker in fields. It's an economic disability. Why? Because it directly attacks his livelihood. So economic disability also attacks someone's livelihood, and that's why this is a direct infringement. This is a direct infringement of Article 21 of right to life and dignity. It's an upfront assault on their dignity. ठीक है? तो पहला क्या हो गया? इकोनॉमिक डिसेबिलिटी. दूसरा क्या हो गया? सोशल डिसेबिलिटी. अब someone is not allowed to enter into a temple, either due to caste or due to whatever reasons. That is a form of untouchability. If someone is not able to go to a public place, does not have an access to restaurant, he cannot take their kids, let's say, to a movie hall, it's a social disability. People are not meeting him in the neighborhoods, it's a social disability. और people are discriminating. So disability का एक और version क्या आया, वो है discrimination. It results in discrimination, and this is prohibited also, not only under Article 17 but also under Article 15, right? So अभी तक हमने 3 आर्टिकल देख लिया, 17 तो हम देख ही रहे हैं. Regarding untouchability, we are already looking at Article 17, but discrimination 15 and dignity, right to life and personal liberty, dignity, Article 21. So it's a very important constitutional provision. Generally हम लोग इसको उतना अच्छे से पढ़ते नहीं हैं. Third, what can be a third form of disability? Can anyone tell me? Political disability. They are not allowed to form a political party. They are not allowed to form a union. They are not allowed to form a cooperative society. They are not allowed to collect as a community or as a group of people. That is political disability. ठीक है? Can we associate at least 2 terms mentioned under the preamble associated with the word justice? Preamble में एक word याद है, justice, social, economic and political, and hence untouchability attacks this aspect of justice mentioned in the preamble to the Constitution of India. So you see, इसका importance बढ़ते जा रहा है धीरे धीरे. एक क्वेश्चन आया था यूपीएससी में कि the provisions of the preamble by themselves are not justiciable, but they become justiciable once they are attached with other provisions of the Constitution, and this is very much true. So these terms, justice, social, economic and political, by themselves, let's say you cannot go to a court, but when you associate this concept with the concept of untouchability or discrimination, then definitely it is a worthy topic to be filed as a writ under Article 32. Okay, can you highlight any other kind of disability other than economic, social and political? And all of this, any kind of this disability, क्या है ये? It is an offense. Any kind of disability is an offense. So either someone either preach or practice, दोनों offense है. Preaching or practice, both are subject to punishment. Both are subject to punishment. Clear? भूलोगे नहीं अभी disability, untouchability? Correct. Educational disability. Okay. It says Rajasthan High Court in Jai Singh versus Union of India and Madras High Court in Devrajia versus B. Padmana has defined untouchability as, write this down, ये लिख लेना. Article 17 में तो जो लिखा है सो लिखा ही है. Court said that in Article 17 the word untouchability is placed under inverted commas, which mean the word is not to be taken by its literal or grammatical interpretation and hence needs to be understood in a wide manner. and the meaning has to be derived from historical development and historical practices. Now this gives essence, this gives sanctity to this word untouchability. कोर्ट क्या कह रहा है, ये जो वर्ड है untouchability ये inverted commas में है, and hence its significance has to be traced from historical perspective. Hence significance has to be traced from historical perspective. Untouchability refers to social disability imposed on certain classes of person because of their birth in a specific backward class. पहली बार एक कम्युनिटी से डिसेबिलिटी को एसोसिएट किया गया. Religious disability if it's not part of social disability, correct, right? So what the court did, the court tried to connect disability also with certain class or caste, and ultimately court said that hence it does not cover any social boycott of a few individuals or their exclusion from religious services. Therefore the word untouchability in Article 17 only means caste based untouchability. Write this down. So mere social boycott of certain group of people is not untouchability. Untouchability is directly associated with caste, not even class. And this historical perspective is associated with someone's caste, that too a backward caste. Because someone is from a backward caste, hence there has been a practice of untouchability. And this is seen from a historical perspective. So court, although क्या definition में article 17 में untouchability के relation में कहीं भी लिखा है caste के बारे में? कहीं नहीं लिखा है. Untouchability, see, it is within inverted commas. Untouchability is abolished and its practice in any form is forbidden. Enforcement of any disability, this word again becomes crucial. Any disability, कुछ भी, कोई भी disability arising out of untouchability shall be an offence punishable in accordance with law. Now to understand disability, let's quickly go through another constitutional provision, namely Article 19. Because disability also affects these fundamental rights. It says protection of certain rights regarding freedom of speech, etc. All citizens have the right to freedom of speech and expression. Let's say someone is prohibited from making any speech or expression because of certain disability. To assemble peacefully and without arms, to form associations or unions or cooperative societies, to move freely throughout the territory of India, to reside and settle in any part of the territory of India, and to practice any profession or to carry on any occupation, trade or business. So if any of these activities are restricted, because these are fundamental rights guaranteed to citizens, अगर ये restrict किया जाता है in the name of caste, then definitely it results in certain kinds of untouchability. It results in certain kinds of untouchability. Clear? Do you understand the correlation between Article 17 and 19? And obviously, there is a correlation between Article 17 and 15. So 17 का correlation 15 से भी है, 19 से भी है, 21 से भी है. Let's go back. So overall court is saying that ultimately untouchability is a product of caste system according to which particular section of the society has been looked down upon as untouchables by the other section of the society. So they were considered as untouchables. And because of this historical wrong, presently they are provided affirmative action in the name of reservation. They say the literal construction of the term would include persons who are treated as untouchables either temporarily or otherwise for various reasons, such as suffering from infectious diseases. Untouchability may arise because of certain disease. Account of social observance, such as or are associated with birth or death, or on account of social boycott resulting from caste or other disputes. So it says in either case, such persons can claim protection or benefit either of Article 17 or Protection of Civil Rights Act 1955. So Parliament earlier enacted Untouchability Offences Act 1955, and now this legislation is, अब इसका क्या नाम हो गया है, Protection of Civil Rights Act 1955, because it not only talks about providing punishment, but it is also talking about an affirmative manner in protection of their civil right. And what is the meaning of civil right? Expression civil right is defined as any right accruing to a person by reason of abolition of untouchability by Article 17 of the Constitution. Please write this down. That the term civil right under Protection of Civil Rights Act 1955, the term civil right under the Protection of Civil Rights Act 1955 is defined as any right. The term civil right under the Protection of the Civil Rights Act 1955 has been defined as any right accruing to a person by reason of untouchability, by reason of abolition of untouchability by Article 17 of the Constitution of India. By Article 17 of the Constitution of India. Okay. We have already seen that discrimination cannot be done on grounds of religion, race, caste, sex, place of birth, or any of them. Different grounds of disability under Protection of Civil Rights Act, as you rightly said, is religious disability, restriction from entering any place of public worship or offering prayers at such place of public worship such as temple, mosque, gurudwara, etc. Restriction from performing religious services like bathing in sacred tank, pond, water course, river or lake. Social disability, refusal on the ground of untouchability to access to any shop, public restaurant, hotel or place of public entertainment. Refusal to use any utensils and other articles kept in any public restaurant, hotel, etc. Refusal of practice of any profession or the carrying of any occupation, trade or business or employment. That's also part of social disability. Refusal to access to any river, stream, spring, well, tank, cistern, etc. Or refusal to use of or access to any public conveyance. Refusal of construction, acquisition or occupation of any residential premises if people are not allowed to stay at any society. Refusal of observance or participation in any social or religious custom. Refusal on use of jewelry and fineries. Refusal of persons on ground of untouchability to be admitted to hospitals, dispensary, education institution, etc. देख लेना एक बार social disabilities. Commercial disabilities arises under all the economic aspects. Whoever on the ground of untouchability refuses to sell any goods or refuses to render any service to any person, and whoever prevents any person from exercising any right accruing to him by reason of abolition of untouchability under Article 17 of the Constitution, then it is also a violation of fundamental right under Article 19(1)(g), that is right to carry on any trade, profession or business. So it's a sort of economic disability also. Unlawful compulsory labor, when to be deemed to be a practice of untouchability. Whoever compels any person on the ground of untouchability to do any scavenging or sweeping or remove any carcass or flay an animal, basically cases of manual scavenging. So that is also a form of untouchability, and the courts have also highlighted that manual scavenging is now a part of untouchability. And these are the laws which has been made to make manual scavenging a punishable offence, and also declare it as a form of untouchability. So it says employment of manual scavengers and construction of dry latrines Prohibition Act prohibits employments of manual scavengers as well as construction or continuance of dry latrines, and for the regulation of construction and maintenance of water seal. Prohibition of employment as manual scavengers and the Rehabilitation Act 2013. This law provides for prohibition of employment as manual scavengers, rehabilitation of manual scavengers and their families. And this I have taken particularly, this was a judgment of Supreme Court in January 2025. क्योंकि ये क्या कहता है, Supreme Court bans manual scavenging and manual sewer cleaning in 6 metropolitan cities. Supreme Court passed directions banning manual scavenging and manual sewer cleaning in 6 metropolitan cities, seeking eradication of manual scavenging in India. So the point which I am trying to highlight is that even manual scavenging has been connected to the concept of untouchability. So Supreme Court in its order also directed the Chief Executive Officer of each metropolitan city to file a precise affidavit showing apprising as to how and when manual scavenging and sewer cleaning is stopped in the city. So basically the court have asked or the officers to come up with a particular solution. Now these are some of the punishment. So it says section 3 to 7A of the Protection of Civil Rights Act define the following as offences if committed on ground of untouchability and lay down punishment for them. Prevention from entering public worship places using sacred water resources, defined, this is punishable offence. Denial of access to any shop, public restaurant, hotel, public entertainment, cremation ground, this is also punishable offence. Refusal of admission to any hospital, dispensary, education institution, this is also a punishable offence. Refusal to sell goods and render services, molestation causing injury, insult, etc. Compelling a person on the ground of untouchability to do any scavenging or sweeping or to remove any carcass, that is manual scavenging. This is also a punishable offence. So all of these are punishable offences, and the fact that untouchability has been associated with the concept of caste-based discrimination. Now in these judgments in PUDR versus Union of India Asiad project, Supreme Court held that fundamental rights under Article 17 are available against private individuals, and it is the constitutional duty of the state to take necessary steps to see that these fundamental rights are not violated. It should be noted that Article 15(2) also helps in eradication of untouchability. And what is Article 15 Clause 2? Let's go through it. So this is Article 15 Clause 2. It particularly say that no citizen shall on grounds only of religion, race, caste, sex, place of birth or any of them be subject to any disability, liability, restriction or condition with regards to these: access to shops, public restaurants, hotels and places of public entertainment. So the element of social disability is also incorporated or provided under Article 15 Clause 2, right? And the use of wells, tanks, bathing ghats, roads and places of public resort maintained wholly or partly out of state funds or dedicated to the use of general public. So यहाँ पे भी you cannot discriminate particularly on the ground of disability, and what the court says on the ground of caste-based disability. In this particular case, Indian Young Lawyers Association versus State of Kerala, Sabrimala judgment also mentioned or focused on this concept of purity and impurity as attracting Article 17. Court ने क्या बोला? Supreme Court held exclusion of women based on menstrual status is a form of untouchability under Article 17, which is an anathema to constitutional values. Notions of purity and pollution which stigmatize individuals have no place in a constitutional order, and ultimately court said that you cannot discriminate on grounds, first of all you cannot discriminate based on gender, and second, gender in a particular situation. So that itself is untouchability under Article 17. So even in Sabarimala judgment, court did go into this element of untouchability. So it's quite possible that a very detailed question can be asked in your main examination, highlighting or asking you to address that how the government has ensured that untouchability is eradicated in the country. So you have to highlight all these cases and also the particular law, that is Protection of Civil Rights Act. In Khadak Singh versus State of Himachal Pradesh, Supreme Court observed that right to life is not merely an animal's existence. And under Article 21, right to life includes right to live with dignity. See this? So Article 17 is also associated with Article 21. Basic human dignity implies that all persons are treated as equal human in all respects and not treated as an untouchable, downtrodden, and object for exploitation. It also implies that they are not meant to be born for serving the elite class based upon caste, and the caste discrimination had been deep rooted, so the consistent effort is on to remove it, but still we have to achieve the real goal. So यहाँ पे भी कोर्ट ने डिस्क्रिमिनेशन और अनटचेबिलिटी को कास्ट से ही एसोसिएट किया है. So if I give you this practice question that define untouchability according to the law made by Parliament. Can we say that untouchability is associated with caste? Give reasons. Marks. Okay. Will you be able to answer this question? Perfect. Always remember, try to associate Article 17 with Article 15, Article 21, Article 19, and preamble plus Supreme Court judgments, obviously along with Protection of Civil Rights Act. This is your summary for untouchability. Particularly Article 15 Clause 1 and 15 Clause 2. Okay. Quickly, let's revise. Article 12 was, let's revise the different articles. Let me see how much you remember. Article 12 highlighted about state. Article 13 judicial review. Article 14, yes Krishna. Equality. Article 15, Krishna, please answer. Equality. And in, sorry, 15 is discrimination. Discrimination plus affirmative action. And in this equality, two aspects, EBL and EPL. Article 16, public employment. Plus reservation or affirmative action, right? Article 17, अभी तो पढ़ा, untouchability. And Article 18 is abolition of titles. Abolition of titles. And among these, from here, it is Article 14 onwards till Article 18. This is a part of right to equality. So today we will end right to equality. Tomorrow we'll start with right to freedom. Okay? You remember this? So let's quickly go through Article 18. Article 18 is very simple. I'll give you the crux. It says that you cannot have titles like the title which earlier people used to have, like Rai Bahadur or different type of titles. तो अलग अलग आप टाइटल नहीं रख सकते, जैसे कि whatever titles used to give. So on titles there are two issues which arose. First of all was that whatever awards are given, like Padma Awards, Bharat Ratna, Padma Vibhushan, Padma Shri, Khel Ratna, इसे सारे जो awards मिलते हैं, can we say that these awards, you know, technically provide you titles, that you are Padma Shri so and so, you are Bharat Ratna so and so, you are Rajiv Gandhi Khel Ratna so and so, you know? Can we say that ultimately title ही तो मिल रहा है और क्या मिल रहा है ना? भाई Sachin Tendulkar is Bharat Ratna, so he is Bharat Ratna Sachin Tendulkar. Is it right to say it like that? Krishna, what do you think? Why? Fatma, why do you think? As in, what's your reason? Ki when we say that we give awards, then it is almost like giving titles.
Sir, but basically awards are for recognizing, like, as per different
Correct.
criteria, for recognizing talents in different fields.
Correct.
So, but yes, we can mention this, like people mention if they are Bharat Ratna or Padma Shri awardees.
Okay. Yes, they are given awards. Okay. So here we need to understand two things. What is the purpose of the award? Purpose, as you rightly said, it is to recognize excellence in human field, isn't it? that's what we are actually doing, that you are recognizing someone's excellence in a particular field, right? So that does not mean we are providing them titles. Titles are something else. Titles are those things which you write before your name or after your name as a suffix or a prefix. Those are titles. Awards are not titles. Awards are recognition. So that is a difference. Just remember this point. ज़्यादा कुछ नहीं है इसमें. That's the only thing here. So it says that no title not being a military. What titles? Military or academic distinction shall be conferred by the state. But the meaning of title is that title is either attached to your name, prior to your name, or post your name. For example, in India, we do not have the concept of knighthood the way it is there in England. We do not have Sir Sachin Tendulkar. But in England, they provide knighthood, and hence the word comes prior to their name. It says, thus the hereditary titles of nobility like Maharaj or Maharaj Dhiraj, Raj Bahadur, Rai Sahab, Diwan Bahadur, etc., which were conferred by colonial states are banned by Article 18, as these are against the principle of equal status of all, and effectively it is against discrimination, or it in a way confers special privilege. Okay? Or you can say it is a violation of Article 15 itself, because then you are categorizing people on certain basis, at least on a hereditary basis. Democracy is never based on heredity. First point. So it says that no citizen of India shall accept any title from any foreign state. अब इस पे भी थोड़ा debate है, discussion है कि भाई what can we say as a title? Can you accept award? Yes, you can accept award, but you cannot accept as a title which is attached to your name. Okay? No person who is not a citizen of India, while he holds any office of profit or trust under the state, accept without the consent of the president any title from any foreign state. So if a person who is not a citizen of India but yet they hold public office, and if they have been given any title from a foreign country, they must take prior consent of the president. And prior consent of the president here refers to consent of the Council of Ministers, because we are a parliamentary form of government. No person holding any office of profit or trust under the state shall without the consent of the president accept any present, emolument or office of any kind from or under any foreign state. So whatever benefits you are being accorded by a foreign government, by a foreign country, it must be approved by the president. But overall it talks about abolition of titles, and in this case a lot of clarity was actually given. In Balaji Raghavan versus Union of India, it says Supreme Court upheld the constitutional validity of national awards Bharat Ratna, Padma Vibhushan, Padma Bhushan, Padma Shri, as they merely denote state recognition of good work by citizens in the various fields of activity, and does not associate any prefix before or after a name. And these awards seems to fit in within the category of academic distinctions. Now this is allowed under fundamental duties, because under fundamental duties it says, or it tells citizens to go for excellence in different fields of work, to strive for excellence in different field of work. And for that purpose, if someone is recognizing your excellence as through an award, then it's fine. उसमें कोई problem नहीं. So Supreme Court ruled that these awards do not amount to titles within the meaning of Article 18, that prohibits only hereditary titles of nobility. So what is prohibited is any title associated with hereditary aspect. कि भाई father को भी मिल गया, बेटे को भी मिलेगा, and all those things. Therefore, they are not violative of Article 18, as the theory of equality does not mandate that merit should not be recognized. However, it has also been ruled that they should not be used as suffixes or prefixes to the names of awardees. Otherwise, they should be forfeit their awards. कोई अपने नाम के आगे पद्मश्री ये अपना नाम ही चेंज करा ले, ये बोल के कि मेरा आफ्टर द अवार्ड समवन इफ चेंजेस लीगली चेंजेस देयर नेम, I am Padma Shri so and so. So then that award will be forfeited. You cannot add that award as a prefix or a suffix to your name. So that is the distinction between award and titles. So this is what has been provided under Article 18. Caste prefixes. Caste are मतलब वो नाम नहीं है, वो टाइटल नहीं है ना, क्या बोलते हैं उसको, सरनेम है. That is more of a recognition of either a class, caste, business occupation, etc. That is not title. Title is technically state conferred. Title is provided by the state. That's a social affirmation, a social recognition of certain community based on history or based on historical aspects. Okay. Before ending our lecture, I would like you quickly go through these two questions at least. Let's go through this question. This one, 2021. What is the position of right to property in India? Tell me, what should be the answer here? Yes, Krishna? Legal right available to citizens only, legal right available to any person, fundamental right available to citizens only, neither fundamental right not legal right. I'll discuss this question in detail, but I just want you to know that what UPSC expects from you. आपसे UPSC ये एक्सपेक्ट कर रहा है यहाँ पे कि आप सिर्फ ये मत जानिए कि आर्टिकल 19 में क्या क्या था, बट ये भी जानिए कि ये जो प्रोविजन हटाया गया ये क्या था, और आफ्टर इट वाज रिमूव्ड फ्रॉम दिस प्लेस वेयर इट वाज पुट. सो अर्लियर आर्टिकल 19 had 1 A, B, C, D, E, F and G. So 19(1)(f) was removed. What was 19(1)(f)? It was fundamental right to property, and this was removed after Constitution 44th Amendment and placed under Article 300A. No more a fundamental right, because as I told you, we cannot locate it within part 3, hence not a fundamental right. Simple. So अब Article 19(1)(f) कहाँ चला गया? So it says originally Article 19 contained 7 rights, but the right to acquire, hold and dispose of property was deleted by Constitution 44th Amendment, and now it is part of Article 300A. The important point to be noted, the difference which happened was that when it was part of Article 19, then it was applied only to citizens. Then it applied, this right of property was applicable only to citizens, because you see under Article 19, protection of certain rights, and in this says all citizens. It does not talk about persons. So under Article 19, it talks about fundamental rights of all citizens, और right to hold, acquire or dispossess property भी एक citizen का right था जब तक 19 में था. But the moment it was shifted to Article 300A, it says persons, not to be deprived of property except by authority of law. It means, simple terms, that if the government wants to acquire someone's property, it must make a law passed by parliament. No person shall be deprived of his property save by authority of a law. And hence the importance of this particular question. Please tell me, do you understand what is being asked here? The whole history of right to property एक छोटे से statement में पूछ लिया गया है, पूरा का पूरा history. ये इतना आसान भी नहीं है जितना दिख रहा है. So now tell me, what should be the correct answer? Correct. बेसिकली हम यहाँ पे एलिमिनेट करेंगे सिटीजन्स नो, नाइदर फंडामेंटल नॉट नहीं है तो कॉन्स्टिट्यूशन में है तो लीगल राइट तो डेफिनेटली है, तो नो, हेंस बी इज द करेक्ट आंसर. कृष्णा, आर यू फॉलोइंग दिस? So to key to understand is Article 19 provided to citizen, and Article 300A provided to persons. And this one says, which of the following categories of fundamental rights incorporates protection against untouchability as a form of discrimination? अब ये तो बता ही सकते हो, अभी डिस्कस किए हैं. पक्का? D? Correct. See, it becomes easier if you understand the essence of any fundamental right. You don't even have to remember untouchability directly. It goes, it is violation of equality. It's a discrimination. In essence, untouchability is a discrimination. Okay? So now are you able to follow whatever we are discussing? It is actually, very serious discussions whatever we are having these lectures. I hope you are enjoying the lecture. I hope you are not hating polity, if not loving it at least. Krishna, has your understanding of the subject developed? Slightly at least? थोड़ा सा भी? So tomorrow let's start with, in fact let's complete छोटा सा article है 19, 20, 21, 22, बहुत बड़ा article नहीं है. Let's try to complete tomorrow right to freedom and freedom of religion, and on Wednesday we'll complete the remaining part including right to cultural and educational rights, because वो थोड़ा सा बड़ा part है and important also considering the recent developments which has taken place. Okay. Any doubts? Okay, thank you.